Welcome. This is the League of Women Voters of Snohomish County Forum for Candidates for Judicial Races. I am your moderator, Nadine Shanti. This forum is designed to introduce you to several candidates running for Snohomish County judgeships. Although each candidate is running unopposed, the League realizes that voters don't have many opportunities to hear from candidates for judgeships. So we hope this forum will help you make informed voting decisions. First, let me give you some background about these positions. The Washington State Court website says that district and superior courts have jurisdiction over both criminal and civil cases. There is no limit on the types of civil and criminal cases heard in superior court. For district court, criminal jurisdiction includes misdemeanor and gross misdemeanor cases that involve traffic or non-traffic offenses. Preliminary hearings for felony cases are also within the jurisdiction of the district courts. A defendant is entitled to a jury trial for these offenses, and juries in district court are composed of 6 people, while superior court juries have 12. All judicial candidates were invited to this forum, and the participating candidates are Beth Fraser, South District Court Position 1, Jeffrey Goodwin, South District Court Position 2, Anthony Howard, Everett District Court Position 1. Also joining us is John Scott. Mr. Scott appeared in the primary as a candidate for Snohomish County Superior Court Position 8. Because he ran unopposed, he has now secured the position and will not appear on the ballot. However, we are pleased that he has agreed to join us for this discussion. The League thanks the candidates for running for office, for their willingness to serve the community if elected, and for participating in this forum. We remind our viewers that it is the policy of the League to be nonpartisan. Therefore, we don't endorse or oppose candidates or parties. We do communicate, educate, and support voters and the election process in our communities. Please note that judicial races are nonpartisan. Rules for participation in this forum were sent ahead of time to the candidates, and they have agreed to engage in respectful communication. Now, let me briefly explain the question and answer period rules, and then we can begin. Questions have not been shared. We thank the community members who sent us recommendations about local issues. Candidates will have either 60 or 90 seconds to respond, and I will clearly state these changes. We're using a countdown timer visible to all candidates, and time limits on answers will be strictly enforced. I will change the starting order for each question, rotating through the candidates to ensure a random and fair sequence. The order for the first question will be as follows: Ms. Fraser, Mr. Goodwin, Mr. Howard, and then Mr. Scott. Please set the timer for 60 seconds for this question, and let's begin. Ms. Fraser, what qualifications and experience make you a strong candidate for this position? You're muted, Ms. Fraser.
If I had a nickel for every time I have heard that,
You'd be rich.
I would be rich. So thank you very much. And thank you for this opportunity to get to be available for voters and to give them more information about what judges do. But my name is Judge Beth Brazer. I am one of the 3 judges at the Snohomish County District Court South Division. And I have been in the criminal justice system in Snohomish County. I think it's been for 34 years now. The past 9 years have been as serving this community as a district court judge, a job that I love because of the contact with everyday citizens. The kind of cases that we handle affect you, your neighbors, my neighbors, name changes, protection orders, small claims cases, traffic cases, and even criminal. Prior to my 9 years on the bench, I was the head of the Office of Public Defense for the county for 12 years, where I was responsible for a multi-million-dollar contract. I negotiated with the executive and the council, and I enjoyed that very much. And prior to that, I was a public defender.
Thank you, Ms. Fraser. Mr. Goodwin, same question.
Good evening, everybody. Thank you for having us here. My experience, I think, prior to going to the bench really helped me prepare to become a judicial officer. I worked as a prosecutor. I worked as a public defender. I had a diverse civil practice as well. So most of the types of cases that I would see as a judge, I had seen in private practice. And then in 2004, I was appointed, and I've served on the bench now the entire time since 2004. I'm active in our association, serving a wide number of capacities. I sit on the Judicial Ethics Advisory Committee. I work with the Rules Committee. I sit on the board of directors for our association. I'm active in our community as well through Rotary, through the Edmonds College Foundation, where I sit as a board member, and for the Linwood Rotary Community Foundation on the board there as well.
Thank you. Mr. Howard, same question.
Well, thank you for having me. I'm Judge Anthony Howard from the Snohomish County District Court in the Everett Division. I've been an elected judge now since 2014. I was an appointed commissioner in a similar type position 3 years prior to that. I guess to answer your question, what I'm most proud of is when I started my career as a public defender and then went into private practice, I started filling in for the judges, actually in the South Division, as a pro tem judge. And after that experience from the court staff and from the attorneys in the community, they really kind of recruited me to the bench in a full-time capacity. It was not really ever an ambition that I had. But since taking the bench, I used my skills that I learned as a public defender and in private practice to really focus this court on alternative resolutions to criminal justice and a more therapeutic approach to address underlying issues involved with people in the criminal justice system.
Thank you. Mr. Scott, same question.
Thank you very much, and thank you for having me. I appreciate this opportunity. I served in Everett as an attorney in Snohomish County generally for 22 years. I was a public defender in Everett Municipal Court. I practiced in the district courts as well as with the Snohomish County Public Defender Association, doing felonies in Superior Court. I have done private practice. I have done public service. I have handled every level of criminal case in terms of what can be tried in Superior Court. I was certified to handle as lead attorney in capital cases by the Supreme Court, and I took very seriously all of those responsibilities and decided that I wanted to be a judge. I went through the vetting process and was appointed to this position by Governor Inslee, and I am serving in it and loving it, and I'm very proud to be a judge and look forward to more years to come.
Thank you so much. Okay, let's see. We're going to get into a little bit more detailed question here. So I'm going to ask our timer to reset us to 90 seconds. And the question will first go to Mr. Goodwin, and it is this. What is your general judicial philosophy or approach?
Thank you. I'm glad you've given us 90 seconds for this one. We in the district court, we really are the people's court. If you're going to come to court, you're most likely going to come to the district court. So you're going to be there for a traffic infraction maybe, or a protection order. Maybe you're a witness in a criminal matter, or you had your vehicle impounded, those types of things, small claims court. So you're most likely to come to the district court rather than to the Superior Court. We have a tremendous opportunity to demonstrate to our community that the justice system functions well. In order to demonstrate that, we need to make sure that everybody that comes to court feels like not only the process is fair, but it's critical that they feel the process is fair. And one of the key components to that is listening. It's critical that the judicial officer hearing the case really listens to what these folks have to say. We might hear 100 traffic infraction cases throughout the course of an entire day, and they're all important. They're critically important to that person that's there. So it doesn't matter whether it's the first case of the day or the last case of the day. I need to listen as carefully and closely and pay attention to that case like just as much as any other case, because it's important to that individual. They feel like the process is fair, and that ensures the respect and the trust in our process.
Thank you. Mr. Howard, same question.
Thank you. Well, I would echo everything that Jeffrey just said, and we try in the district court world to really meet those goals. It is difficult. We're a high volume court. There is pressure to get through a docket, and in fact, to do this job properly, you need to get through the docket. And so to do that and also make people leaving the courtroom feel like they were heard, and that they were treated fairly, and even when they disagree with you, that they have respect for the system that just resulted in a decision. I often tell people that I focus far more on communicating well with the litigant who is likely to lose than the person who's going to win. The person who's going to win is likely to leave feeling like justice was served and they're happy, but it's that person who loses, and I say lose, when the person doesn't prevail in what they want from the court, they need to leave feeling like they were treated fairly, like the judge listened to them, like they had access to the court. So regardless of whether they speak English or they need some other accommodation for a physical or mental disability, that we have listened to them and that we've provided them the best possible justice out of the limited resources and limited time that we might have to devote to their particular case. And I think we're doing a much better job than we used to in these areas, I will say, largely because of Judge Fraser and Judge Goodwin, and hopefully myself.
Thank you. Mr. Scott, your thoughts?
What I said when I was asking for support for this position and going through the process of appointment, what I told everyone was that what I would do is I would be well prepared and I would be fair. That's all I ever wanted from any judge I ever appeared in front of. It is what I promised to give all the attorneys and all the litigants who would appear in front of me. And that's my judicial philosophy, is just to be well prepared and to be fair, to have read the briefs, to have thought out questions that are important to the result, to give those questions and give the attorneys a chance to answer those questions, and to come to a fair decision based on the things that I hear. That's all I wanted as an attorney, and that's what I'm going to deliver as a judge.
Okay, thank you. Ms. Fraser?
I thought you would call on me next. As you may have gleaned, we all know each other very well. We've all worked together for many, many years and have a high degree of respect for each other. I echo wholeheartedly what Jeffrey and Tony have said, because it's a joint judicial philosophy that our entire bench has. We work amazingly well together because we have a common vision. But for me personally, I want people to see the court as I do, which is as a critical and positive part of our community. Sometimes it can be easy to look at district court and say, oh, well, the smaller cases are heard there, not the more serious cases. But as Jeffrey said, each case is important for the person who comes into our door. And I think that it's important to try to communicate, to lessen the fear. Most people are really nervous or frightened when they come to court, and it's usually because they don't know what to expect. So they imagine the worst. I feel that it's my job to help explain things to them, to help demystify what's going on. As Judge Howard said, there might be one person who's happier than the other at the end of a case, but if both parties fully understand why we got to that point, it's a better solution. I also feel that the court needs to take a therapeutic approach, that is more helpful to community building. And I know the rest of the bench supports me in that. I've just taken over the mental health court from Judge Howard.
Oh, okay. Thank you. Mr. Howard, this question will go to you first. How would you help the public better understand the workings of the court that you serve?
Well, that's a good question. I've tried, one thing about running unopposed and yet doing events like this is it gives us an opportunity to get out there and explain to the public the good work that the courts are doing. So much of what we do is behind the scenes and only seen by the particular litigants that we might have before us and the lawyers. But one thing is participating in events like this, and I appreciate the fact that this is intended to be broadcast on the radio so that we can get as many listeners as possible. In addition, I've been to many of the sort of legislative district meetings. I've been dedicated, as I mentioned before, on a therapeutic court type approach. And so over the years, I've attempted to implement a community court, and I can get into more detail about that later if you wish. As Judge Fraser mentioned, I was a mental health court judge for the last 3 years. And getting out there and letting people know that we're not just churning through cases in our courtrooms and then going home, that we're participating in community events. We're, I think, all in leadership positions in community service type organizations, and getting out there and talking to people about sort of the innovative things that the courts are able to do. We are sort of bound by the limitations of the law and sort of the traditions of a court system. But we're really, I think, doing a good job these days of going outside of that and trying to find new solutions to old problems.
Thank you. Mr. Scott, your thoughts on that question?
I would mirror that answer. The key is to be out there and open, be in the community where you can, talking to people who have questions, being responsive to forums like this, where people can ask questions and we can answer them with regards to what the court's doing. I serve as a coach to the Jackson High School mock trial team. I've done that for the last 3 years. And that's a great opportunity to sort of teach young people about the court, to talk to their parents about things we're doing, to answer their questions. But I think the key to it is just being open and available when people want to talk about those things in these kind of forums or others.
Thank you. Ms. Fraser.
Thank you. I think, unfortunately, to echo what everybody else has said, events like this are really important because you're right. So few people have any idea of what judges do or what really happens in courtrooms. I try to invite people to come to the court. And since this is being broadcast, I'd like to remind your listeners that it's an open court. Anybody can come in. And we do have people who sometimes I'll get to the bottom of a calendar and I'll say, "Sir, I see you're still at the back of the courtroom. Have I not called on you?" And I'll find out that it's just a member of the community saying, "I'm just here to find out what happens." We love that. When we have interested people, we're happy to take the time to explain the kind of calendar that we've just had. At Snohomish County, at our court, South Division, we have for the past, I think, 35 years, other than COVID, hosted Law Day, where we have had about 800 fifth graders come through our court to start early with helping kids see that the court is not something to be afraid of. It's a part of your community. We have officers come in with dogs. We do a law jeopardy. We have a mock trial. So starting early, I've volunteered for several years in the past with mock trial competitions. That's another great way. Spoken with different classes. I'm one of the co-chairs of the District and Municipal Court Judges Public Outreach Committee, and we're going to be using social media to reach the public about what we do.
Thank you. Mr. Goodwin, your thoughts on that question?
Yeah, thank you very much. Community outreach, I think, is the best outlet we have to get out and do this. These types of forums are critical. I'm really pleased that this forum is being broadcast because it will allow wide access to the Q&A that we're going through here now. Inviting people to court is another great way to do that. We can do that through through the community service outreach that we're doing. Belonging to service organizations, belonging to the Rotary Club or another service organization, getting involved with different community boards, like my involvement with the Edmonds College Foundation Board. That's a really great way to reach out. I love the idea of going to LD meetings. We try regularly to get to the LD meetings just to get an update on what the courts are doing. And every time that I go to one of those LD meetings, I keep thinking we've got to do this more regularly because it's an opportunity to reach out to other elected leaders and members of the community to show what the court is doing. That's a great time to invite those elected leaders to come to the court as well. Another great interaction is with the jury pool. So when we have a jury pool in court, we've got a large number of people there. They don't all serve as jurors, but an invitation for them to come back to court or to stay and watch the proceedings. Judges in the Classroom is another important program that gets judges out into the elementary schools, middle schools, and high schools.
Thank you all for all of that information. That was very informative. Our next question is, we're going to start with you, Mr. Scott. And it's, what do you perceive are the greatest obstacles to justice today in our state? And what would you do to overcome or mitigate those obstacles if you believe they exist?
That's a big question. We have, I think, with the most recent times, we have the backlog of cases. That's comes from COVID, and that has stalled everything. So we have criminal cases that are backed up. We have civil cases that are backed up. We are addressing that as best we can with new judges, new procedures, some streamlined procedures such as the Zoom hearings that were started during COVID to get through that. That is the main thing I think that's on the front burner for us in terms of just getting people to court, into court, getting their hearings heard, getting their trials heard, because there is a very big backup. But we're working really, really hard to get that done and to get through that. It's a resource question, it's an efficiency question, and we're kind of handling on a day-to-day basis. Beyond that, there are the usual access to justice problems that we've faced historically, which is to be able to inform people who may not know that they have certain rights and remedies, that those exist, and to be able to advise them and educate them as to the avenues to get into court and to seek redress for things. And we see, with clinics such as landlord-tenant clinics, dissolution clinics, those are the best ways, I think, for those outreach programs to work. We just need more of that and just the hard work that goes with it.
Thank you. Ms. Fraser, your thoughts on this question?
Thank you very much. It's a multi-pronged situation. We face every day people who have financial issues in terms of housing, in terms of employment. It's hard to get somebody into court to deal with their obligations when what they're worried about is, when am I going to have the roof over my head next? How am I going to make myself safe? How am I going to make my kids safe? So trying to meet people where they are and understand that people have a lot of basic needs that aren't necessarily being met. And it's not so unusual to think that they would take care of those maybe ahead of a court date. We have really shifted in the past couple of years at our district court into a far more therapeutic and assistance-oriented probation. How do we help people meet their basic needs so that they can then address their court needs? Because they still need to be responsible for the court responsibilities. We have a lot of people with mental health and substance use disorder issues. We have a very vibrant mental health court that Judge Howard has passed on to me, and I've just started with, trying to meet people again where they are and get them the resources they need to build a better community. We also need to have people have more faith in the courts. Courts need to look more like the people we serve, and we need to offer people opportunities, and we're doing that.
Thank
you.
Thank you. Mr. Goodwin, your thoughts?
Thank you. I'll echo that. Just access to the courts is a critical issue. And this experience we've all gone through with the pandemic and the rise of Zoom hearings has been really interesting for the courts. There were a number of us who were skeptical about the process, how well it would work. Was our technology going to meet the needs? But imagine if you are struggling in any way to pay your bills, you need to keep your job, and then you get a summons to appear in court. Well, before Zoom, you would need to take a day or a half day off work that maybe you couldn't afford to do. Now you can take a short break from your job. You can appear for a hearing by Zoom. Lots of different hearings lend themselves really well to those remote appearances. If you've got a criminal case, but it's just going to be continued, That's a great opportunity to do that. We even permit now you to do that just through your attorney. So you don't even have to appear as the defendant in court if your case is going to be continued. But traffic court hearings, those types of things lend themselves well. One of the other challenges that we're having now that I think is a real access issue is access to interpreters. We are having a very difficult time at times making sure that we have, with the breadth in our community and the number of different languages spoken, to have interpreters that are available. So we're working to see if we can increase the number of interpreters available to the court.
Thank you. Let's see, where am I? Mr. Howard, in question.
Yeah, I agree with everything everyone said, and rather than repeat that, I have a major concern now with just the lack of respect that our institutions in this country are going through, and it is transitioning into the court system. And if we have a public who doesn't respect the courts, we are not going to get the outcomes that we all desire. And so I think it's critical that those of us in leadership positions at a high level try to bring respect back to the courts. And that's by doing many of the things that we're talking about. We're here all acknowledging the fact that the public, to a large degree, doesn't really understand what judges do, many of them. And one of the things we need to do is make sure that the public understands the critical role that we play and that they can trust us. We all are leaders in our community. We do have political opinions, but we are not like at the federal level. Politics really does not come into our courtrooms. We are professionals. Judges, although they may have personal opinions, do not let that influence their decisions that are made on law and facts. And I think all four of us here today would tell you, we oftentimes make a decision that we might not personally agree with, but it is required by both the law and the facts. And the public needs to know that that is a reality. We are professionals.
Thank you all for your responses. Those were eye-opening for me. Thank you. Ms. Fraser, this question is for you. Should the composition of criminal and civil juries reflect that of society at large, and why or why not?
Can you repeat that for me?
Sure. Should the composition of criminal and civil juries reflect that of society at large, why or why not?
Thank you. That is a really big question, because we try, at the most basic core, we need to have a fair and impartial jury. And another issue that we've talked about is that you need to have a community that has faith in the justice system. And part of that is feeling that you are being judged by a panel of your peers. We do the best that we can when we send out jury summonses to have the most random and diverse pool of prospective jurors who come in. It is with your voter registration and your Department of Licensing application from which we draw the pool of prospective jurors. But I do think that's important that for people who are, whether you're in a criminal case or a civil case, the appearance of justice is as important as actual justice. And to have a jury that reflects the composition of the community is a goal that I think we strive for. It's not always easy to achieve. Our focus, as I said, is on a fair and impartial jury, but I understand that a lot goes into that.
Thank you.
Thank you.
Mr. Goodwin, your thoughts on that question?
Thank you. I agree. I think that we have a very diverse community, particularly down in South Division, where we're in the heavily populated southwest quadrant of our county, around the Linwood area. And so we have a very diverse community there. Our jury should reflect our community. We have a specific court rule in effect that limits the ability to exclude jurors from underrepresented populations. And so that's helped to make sure that somebody from an underrepresented population isn't excluded from jury duty on a peremptory challenge. And a peremptory challenge would be one for which no reason necessarily has to be given. So that means that we are keeping a more diverse jury population, and that's a very good thing. I think our paramount duty, regardless of the composition of the jury, is to make sure that the jury's fair. So that is our, regardless of the panel that we have, that's our paramount duty, to make sure that both sides have the opportunity to inquire of the panel and then to select that jury to represent their client's best interest, whether it be the government or whether it be an individual client or a civil client as well. So great question. I'm not sure what we as judges can do to increase the diversity, but we can certainly protect that once they get to us.
Thank you so much. Mr. Howard, your thoughts?
I'll sort of take that baton from Judge Goodwin.
Thank you.
So just for the benefit of the public, we receive a pool of jurors that is provided to us. The court does not actually go out and find a pool of jurors to bring in. And to be honest, I don't even know the intricacies of where that pool comes from because it is presented to us on the day of trial. And then we have, in the district court level, we're again looking for a 6-person jury. So we may have 22 to 30 jurors who would appear. And then that's the pool that we have to draw the 6 people from. And so we have to utilize the tools available to us to make sure that the parties are not excluding jurors for an inappropriate purpose. And so GR 37 is the rule that Judge Goodwin referenced earlier. And it really has opened up the door for judges to disallow parties from excluding jurors from a minority class that oftentimes parties, frankly, historically could get away with excluding because the nature of a peremptory challenge is you don't need to give any explanation for exercising it. And this rule allows judges to disallow that if you can perceive some bias in their decision-making and excluding that particular juror. And so I know that there's a lot of nuance in that, but I agree with the panelists.
Thank you. Mr. Scott, same question.
The panel of our juries should definitely reflect the composition of our community. It often doesn't. The Supreme Court has done, our Washington State Supreme Court has done some kind of amazing things with regards to trying to promote racial justice, to try to promote the inclusion of minorities where they had been otherwise excluded, with the court rules that we're talking about, with their call to have courts be more inclusive. They wrote a letter to the legal community in June of 2020, which was inspiring, really. And we need to take that up and kind of go with it. The problem really is what Judge Fraser indicated. The way that the larger jury pool is drawn is not chosen by the courts, but it's done by rule, which says that it's drawn from Department of Licensing records and voter records. That is a natural process which will naturally exclude many people from the pool, people especially who are living in poverty, people who have been excluded by the system. And we need to figure out a way to expand that, to expand the resources, to get better jurors or more expansive jurors, and to get more people in the pool. And that would be great.
Thank you. And sort of a related question, Mr. Goodwin. Should the diversity of judges reflect the diversity of the communities they serve? Why or why not?
Great question. Yes, it should. And I think the short answer to that is that it promotes trust and confidence in the system. Having a diverse group of judges hearing cases, and you've got a diverse group of citizens in your community, that promotes, I think, increased trust and accountability in the justice system. So how do you get there? Well, I think one of the things that we can do as judicial officers, we can talk, we're limited in what we can talk about, but one of the things we can talk about is the law and the legal system. And we recently addressed an ethics question on the Ethics Advisory Committee about whether a judge could do an ad for a law school, and decided that that was perfectly acceptable for that judge to do so because it promoted the law and the legal system. If you're going to schools, to law schools, to colleges as a judicial officer and talking to the students there about the benefits of serving, of going and getting a law degree and ultimately serving on the bench, you have an excellent opportunity to increase diversity. And so I think that's how that's done. That's what we as judicial officers can do to improve that.
Thank you so much. Let's see, Mr. Howard, your thoughts on that question?
When this question was asked, I immediately thought back to, I'll use an example. So one of the best training sessions I've ever been to is one on the use of interpreters in the courtroom. And Judge Galvan in King County, she set up a courtroom and we all were witnessing a hearing being done in Spanish that we could not understand without the assistance of an interpreter. And they put the interpreter on the mic. And we had to try to experience an arraignment and understand what was happening while the interpreter was in real time translating from Spanish to English and letting us know what was being said. And it was incredibly difficult for me to understand what was happening. And I know how courts work. I'm in a court every single day. And so to imagine someone who doesn't speak English coming into that environment, and even with the assistance of an interpreter, understanding what's happening is asking too much. Well, we then elected Judge Lopez Shaw a couple of years ago, the late Lopez Shaw, and she described holding a hearing in Spanish in her courtroom where the interpreter was interpreting to the English speakers in the room, and she was able to speak to the litigant in Spanish. And what a profound impact that had on people's view of having a judge who looked like the people in the community.
Thank you. Ms. Fraser, your thoughts on this question?
Thank you very much. Yes, absolutely. The diversity of judges should reflect the diversity of the community. And the reason is, as Judge Goodwin indicated, it's because it promotes trust in the justice system, which is critical if we are going to move forward. And it seems to me that access, creating opportunities, and supporting people of the diverse community is critical. So getting kids into courts early, like with our law day that I explained to you, where we have about 800 fifth graders come through a year, getting a diverse group of students to come through and see the court as a positive institution. Helping people of diverse backgrounds consider law school as an option for them, and then helping them, writing letters, supporting them, being there when they need you. Inviting people of a diverse background to pro tem judge, substitute judge when we have openings. We do trainings where we invite people from a wide array of bar associations to come and send attorneys for training to be pro tem judges. And then finally, when they're running for judge, support them, doorbell for them, speak for them.
Thank you. Oh. Mr. Scott, your thoughts on this question?
Yes, I think that diversity of judges should definitely reflect the diversity of the community. As many of my colleagues here have said, that's important for the appearance of fairness, so that people can see other people in roles of authority and identify with them, but it's also critical in terms of bringing a different perspective to the bench, to bring a perspective that isn't there. A diversity of perspective is just as important as the way things look, because judges are asked to rule on things, how facts relate to the law, and their life experiences sort of inform those decisions. And so it's very important that there is a diverse set of life views from different people that can give those rulings meaning and give the court better judgments.
Thank you. Okay, this next question is for Mr. Howard. If you observed bias, unfairness, or other discriminatory acts by attorneys, parties, witnesses, or observers in your courtroom, how would you deal with such acts?
Well, I think we all have on a semi-regular basis, I would guess. And we all need to remember that we're in the black robe, we're up there in front of the room, we're sitting higher than everybody else, and people expect us to be leaders. And so when I observe discrimination, bias, or outright racism in my courtroom, which I have, you cannot just let it go. You need to address it directly, obviously respectfully. You cannot let you can't get out of your judicial demeanor, but you have to call it out, not just for the person who may be committing that discriminatory act or saying that racist thing, but for the benefit of everyone watching. This is a public hearing. You have people in the courtroom. You have people who may listen to the recording later. We now are on Zoom, and you must set an example as a leader and do not let that go. And so we do have certain tools at our disposal, other than the public shaming that someone might need to experience. I have held people in contempt before, and we can impose up to 30 days in jail and a $500 fine for contemptuous behavior in our courtrooms. And we should be willing to go that far if we want to send a message that the behavior is unacceptable.
Thank you. Mr. Scott, your thoughts on this question?
I would agree with Judge Howard on that as well. It needs to be called out directly and immediately and addressed on the spot, because if it's not, then it just lingers. And if you allow it in your courtroom, other people will see that as being allowed in your courtroom. And then it empowers people to sort of express those negative things in other ways. And so when it's observed, when I observe it, I would call it out. I would address it immediately and directly and make it clear that that it's not okay, that it can't continue, and take whatever actions I needed to take from that point forward.
Thank you. Ms. Fraser, same question.
Well, thank you. Of course, we have a responsibility to address this kind of behavior when it happens in our courtroom. The responsibility is ours. We are the ones in the black robe sitting in the high seat, and everybody is looking at us to see what we are going to do. And silence may have a lot of different reasons, but silence is always going to be interpreted as assent. So unless you can call it out, you are agreeing with it. So as Judge Howard said, we do have tools in our toolkit, from stopping immediately and addressing it calmly and clearly and forcefully, all the way up to contempt. We have the ability in Zoom calls to stop someone. We can cut their audio right away so that people don't need to continue to hear that. And that gives us the ability to address people. It's uncomfortable that we have to face this in this day and age, but it is ultimately our responsibility, and we set the tone. And if we don't do anything, then we have agreed with the statement.
Thank you. Let's see, I am at Mr. Goodwin. Your response.
Thank you. Any type of inappropriate conduct needs to be addressed, and it doesn't matter who it's coming from. It needs to be addressed. There are a number of things we can do. First of all, we have a number of rules and procedures that apply to inappropriate conduct. And so we need to understand those rules and procedures, and we need to know how to apply them. Contempt is one of those procedures that we can use if we need to. How you address that type of behavior, I think, really depends on when it occurs. And so if something like that occurs in the middle of a jury trial, as opposed to a traffic hearing or a protection order hearing, something like that, I think you need to be a little more careful in how you address that, because it needs to be addressed, but you still need to make sure that you're protecting the integrity of the jury process. And so you want to make sure that the panel is only getting information that relates to the facts of the case. And so you might need to take the jury panel out first and then address that situation. If it's something that happens in a hearing where we don't have a jury, the proceeding needs to stop, and that needs to be addressed immediately. And it depends on the severity of what that comment is or that conduct is. The more severe it is, the more likely you are to draw a contempt sanction and let that person know that's completely inappropriate. The person has an opportunity to purge the contempt and apologize.
Okay, thank you. This question will go to Mr. Scott first. If you observed a party in your courtroom being poorly represented by an unprepared or an ineffective lawyer, how would you handle that situation?
It's very context dependent on how that would be handled. It depends on what kind of hearing it was, and what kind of procedure, where in the proceedings it was. There are different things that a judge can do in that situation practically. Reset the hearing if need be, ask many questions of the attorney, find out exactly what they are missing, why they are unprepared, what's going on, and make that determination. If someone is definitely getting ineffective assistance of counsel, I can remove them as counsel. I can say that you are not providing adequate or effective assistance of counsel. It would rarely be that bad. You have shades of gray that go from that to someone who is just missing certain points. But it does need to be sourced out in the hearing if it is so bad that it's brought to the attention of the court, and to determine exactly what's going on. If they're just a bad lawyer who are making bad choices, or if they are completely unprepared and really don't know what's going on, or can't effectively represent their client. That would need to be addressed.
Thank you. Ms. Brazer, your thoughts?
Thank you. Can you restate it? Because the words that you've indicated are critical, I think.
Okay. If you observed a party in your courtroom being poorly represented by an unprepared or an ineffective lawyer, how would you handle the situation?
Okay, thank you. I agree wholeheartedly with Judge Scott. I think the first step needs to be that you need to assess what is going on. You may see a party acting in a way that you think, I certainly would never have represented somebody that way, but maybe they are making a very interesting strategic decision on their case. And I should not have the ability to make, to push myself into a strategic decision by an attorney. However, if it's clear that it is an ineffective or unprepared attorney, how can you safeguard the current situation? Like Judge Scott said, is this a situation where I can stop the hearing and say, we're going to set this over? And maybe you need to talk to the attorney. Maybe you find out that they need better training, and this is a discussion that you can have with their supervisor. We have done that before. Maybe you find out that somebody has got a mental health or a substance use issue, there is a lawyer's assistance program through the Bar Association where people can get assistance for that. When I was at the Office of Public Defense managing defender contracts, I removed an attorney from their caseload because of mental health issues. So figuring out what the problem is, protecting the litigant, and getting help for the party, I think are all critical.
Thank you. Let's see, Mr. Howard, your thoughts?
Yeah, it's easy to answer if we just accept the fact that the attorney is being ineffective under the rules of professional conduct, but there's a massive gray area there. And sometimes as a judge, you don't necessarily know the intricacies of the relationship between the lawyer and the client and what the lawyer may be doing at the request of the client, even if it's bad strategy. And so I would be careful about it, but I always keep a copy of the rules of professional conduct for attorneys on my bench. And I oftentimes will ask questions relating specifically to an RPC, the rules of professional conduct, to see if the attorney can answer those questions. Also, we do have the ability, particularly what you really are most concerned about and what comes to my mind in this context is someone perhaps entering a guilty plea to a crime that they are giving signs that they don't necessarily want to do or feel is the right thing to do, but the attorney is recommending that. And we do have the ability to have a back and forth with the defendant while that process is happening to assure ourselves that they are doing so of their own free will, voluntarily, without pressure from their lawyer. But we also have the ability to go to supervisors. If it happens to be a public defender or a prosecutor, I've called the supervisor afterwards, not to talk about a particular case, but to talk about the conduct or judgment of a particular lawyer.
Thank you. Mr. Goodwin, your thoughts?
I think we've all witnessed that as judicial officers. I've been doing this for a long time, and I've seen that happen in several instances. And I think when it occurs dictates how you respond to it. Also keep in mind that I think there's a large distinction between a criminal and a civil proceeding. I think it's a much more weighty issue when you see that happen in a criminal proceeding because of the potential for loss of liberty and the downstream impacts of having a criminal conviction. So I think that's a little weightier situation for that. A number of my colleagues had indicated that something that might initially appear to be ineffective assistance of counsel could be a strategy. For example, a defense attorney might not object to a particular piece of evidence coming in where I'm sitting on the bench thinking, I'm not understanding why the defense attorney isn't objecting or why the prosecutor is not objecting, but it could be part of a legal strategy to have that piece of evidence come in. So I'm very reluctant to interrupt the proceedings right then and question anybody about that. And again, remember, you might have a jury, so you need to be mindful of what to do if the jury's there. That might result in a recess. Sometimes it's questioning the parties, the attorneys, about why that might be, maybe even talking with a supervisor, and ultimately might be a complaint to the Bar Association, worst case scenario.
Thank you. Well, you all have given us some great answers tonight, and we have, very thought-provoking answers, and I really appreciate it. I would like to tell our timer to please let us keep the timing at 90 seconds. I think we have time that we can allow a full answer on this final question. You all have done a great job of answering the questions that we've presented, but we'd like to give you an opportunity to touch on something that maybe we did not. So our last question will go to Ms. Fraser, and it's what additional issues or information would you like to bring to the attention of the community?
Well, thank you very much. What I would like to say is, we know that people don't always have a clear understanding of what judges do. or who judges are, or what happens in courthouses. I just want to remind everybody that we have open courts and we welcome everybody to come. If you are interested in knowing what we have going on in a particular day, you can call the court and ask what kind of hearings we have going on. We have different hearings in all of the courthouses every day. In district court, we hold court Monday through Friday. We have full business hours. We are working on updating our website so that you can come on to our website and check and see what's there, but come and find out what we do. Sit through a hearing, stay till the end. If you've got questions about what happened, judges are happy to speak with you. And we're happy to try to demystify what we do. So you all are welcome. So thank you.
Thank you. Mr. Goodwin, same question.
I think I would like the community to know that you should be extremely proud of the district court that serves you, the judicial officers and our clerical staff and our management team. We have an extraordinary group of very dedicated individuals. I'll give you a couple examples. Through the pandemic, when the pandemic hit, we had to respond incredibly quickly to figure out what are we going to do in order to continue having hearings. And one of the things I'm most proud of is that our courts never closed during the pandemic. We didn't have a lot of in-person hearings, but the courts themselves never closed. We are always open in order to serve the public. If you needed information or you needed to file something with the court or seek a protection order or file a small claims case, you could do that. I'm extremely proud of the speed at which we moved to Zoom hearings. We gave our director and her management team a lot of support, but a lot of that had to be done through our director, Kathy Taylor, to make those things happen. And she did incredible work along with all of us. I want to thank you should be extremely proud of us as judicial officers. We work very well together. We work collaboratively. We meet monthly. We talk about issues. An incredible amount of give and take. So I think you should be extremely proud of your district court as public servants for the community.
Thank you. Mr. Howard.
I really want people to know that judges, we do this job because we care about people. We are public servants. And so I think generally the public sees us, we're in this black robe, we're up there in sort of this visually elite status, and they forget that we're just really human beings. Those of us on the bench, I guarantee you, we are doing this job because we really just want to help people. We all could be making much more money in private practice, I guarantee you. So we are doing this job not for the title or the robe or the status. When people come to my courtroom, I want to help them. And people find themselves in our courtrooms for various reasons, but for the most part, particularly in the criminal context, they are there because of an underlying untreated condition like a mental health condition or a substance use disorder or serious trauma in their lives, and they find themselves in a criminal justice system that historically has not done a very good job of helping them get out of a bad cycle. And we are really trying to dedicate ourselves to helping people address those underlying problems so that they can stay out of the system forever and not see us again. And so I just want people to know and see judges as just real people. It is an important job, but we're really just there to help folks. And you'd be surprised sort of how nice we are.
Thank you. I don't think I would be surprised. Mr. Scott, your thoughts?
Well, we are very nice. It's true. I think I would mirror what Judge Goodwin said. What has been amazing to me in Superior Court is to watch how complicated this process is. We have 17 judges now, all working different types of calendars. We have a juvenile court, and to watch the level of efficiency and the dedication that the staff, the clerks, our court reporters, our law clerks, the dedication they have to get through every day. I can't count how many of our judges both at the district court and in the Superior Court level, have had COVID, and the number of staff that have had COVID and have been out. And other people will come in, they will fill the void and make sure that the hearings can go off, to make sure that the Zoom settings are right, that the technology works for everyone, and to keep everything on track as much as we can. And now that we are getting back to a situation where we can actually have the jury trials, it's twice as much work, because there's so much to do, because it's all backloaded, and yet we handle it because of the staff efficiently. We have juries come in, they're selected. It's just an amazing process that takes so much work, and I am amazed at the staff and the clerks at this court.
Thank you all so much. What an informative night. I actually had difficulty staying on track. I would finish listening and go, oh, who's next? We really appreciate you all for joining us and for running for office. A recording of this forum and others will be available on the League of Women Voters of Snohomish County website and YouTube channel. Find links at lwvsnoho.org. We encourage you to explore additional information about these and all candidates. The Snohomish County voter pamphlet will be mailed to residences starting October the 8th. And vote411.org, sponsored by the League of Women Voters, is another excellent source for nonpartisan voting information. Ballots will be mailed on October 20th, and Election Day is November 8th. Please be a voter. This concludes our candidate forum. Again, thank you all of you for joining us.